When you go into a retail outlet to purchase sugar or any other household products, at what point have you legally entered into a contract with the seller? The Sale of Goods Act of 2012 states that you enter into a contract of sale once you request for the product or service. Section 5 of the Act states a contract of sale may be made in writing, either with or without seal, or by word of mouth, or partly in writing and partly by word of mouth, or may be implied from the conduct of the parties. There have been a lot of concerns about online purchases, with some shoppers complaining that what they ordered was not what was actually delivered. Social media is awash with complaints from shoppers about the color, size, quality, and even delays in delivery of orders. How can a dissatisfied customer go about it? When you order online, the law stipulates that the supplier discloses information about the pricing, description, and all matters pertaining the product and how you will access your product. The Consumer Protection Act states, before a consumer enters into an internet agreement, the supplier shall disclose the prescribed information to the consumer. A supplier shall deliver to a consumer who enters into an internet agreement a copy of the agreement in writing within the prescribed period after the consumer enters into the agreement. A consumer may cancel an internet agreement at any time from the date the agreement is entered into until 7 days after the consumer receives a copy of the agreement if the supplier did not disclose to the consumer the information required. But what happens if upon delivery you are not happy with the product? The buyer may reject them, but if the buyer accepts the goods so delivered, he must pay for them at the contract rate. If the product is delivered in excess, the buyer may accept the goods included in the contract and reject the rest, or he may reject the whole. And if the buyer accepts the whole of the goods so delivered, he must pay for them at the contract rate. You are not bound to return the rejected goods, but informing the seller of your refusal to accept them is sufficient. Betty Kiptum, The Law.